So the Register of Directors and Secretaries is the second major registry that we'll look at. And Hong Kong significantly amended and modernized its treatment of the Register of Directors in the most recent Companies Ordinance, which came into effect in 2014 and was adopted by LegCo in 2012. Right? So this complies with the Protection of Private Data Ordinance. So essentially what we have is we have a register of directors and secretaries, and every member and any other person must be given access to this. However, some information must be recorded and kept by the company, but it may be withheld from the members. This will be a shareholder decision. And it must be withheld from the general public so that the general public does not have access to this private data about directors. And the two aspects that were considered to be private data are the director's residential address and the director's identification document number, whether it be a Hong Kong identification number or a passport. And this follows up a number of, during the 1990s and 2000s, attacks on directors for political and sort of special purpose reasons. In the UK, companies involved in animal testing or the use of fur from animals had suffered attacks on their directors at their home addresses and threats to their children and their family for involvement in these activities that certain groups consider to be objectionable. In Germany, the head of the management board of Deutsche Bank was blown up coming out of his home. His car actually was blown up on the street just outside of his driveway. And so generally a move began in the 2000s to allow the directors to use their business address, but to keep their private home address where they live and where their family lives out of the public eye. And Hong Kong steps into this and uses the same sorts of protections, right? So we have information being given to the company's registry, and the company's registry must protect this information as private data, but keep it available in cases of, say, disciplinary proceedings. The company's registry also keeps an index of directors, which shows the various positions that directors hold in various companies, and this is quite useful if you want to study the quality of governance in Hong Kong. Now, this balance that was brought in 2014 is not in effect. And the reasons it's not in effect is because American newspapers did not like it. American newspapers were using the company's registry to investigate the investments of Chinese Communist Party officials in Hong Kong companies. And they found it useful because sometimes they couldn't understand the difference between one Chinese name in Romanization and another, because as you know, a Chinese character sometimes 5 or 6 or maybe at least 3 Chinese characters might be Romanized with the same word in English. And it was difficult to understand the distinctions between the last names of directors, so they would use the residential address and the Hong Kong ID number in order to distinguish between them. And they found the company's ordinance availability in the company's registry of the residential address and the Hong Kong ID very useful to their purposes. And so strangely, and I think this is, for anyone who lives in Hong Kong, you certainly should pay attention to this. Remember that the Hong Kong Companies Ordinance was adopted in July of 2012. In 2013, the New York Times finds out about this and publishes an article basically saying that there is proposed legislation in Hong Kong, which is a cover-up. And we also have a similar article by Bloomberg arguing that the Hong Kong government is seeking to cover up information by making it secret. So journalists objected to this. And then at the end of the day, we even have the president of the Small and Medium Enterprises Association. And this is someone whose job is essentially to advocate the interests of directors in small companies, because these directors are usually the owners of the companies. And even this person finds that his own clients do not deserve a right of privacy at their home and for their personal identity numbers, and argues that Hong Kong has thrived on transparency. Transparency is a good thing, and so transparency should be continued. LegCo then reacted to this by suspending. You can take a look at your copy of the ordinance. LegCo suspended these provisions, so they are not in effect. And this is very interesting for a student of company law, because you should really be thinking about what transparency is and why members need transparency. One article that was published in the debate at the time when this was being considered was that often restaurants in Hong Kong closed down without the company paying full wages to employees. And so the best way to ensure that the employees were paid by the company was for the ex-employees of the company to be able to go to the director's home and demand payment. So you could simply think about this for a moment. Does the director owe payment for the debt of the company? We've learned about limited liability. No. How normally do we advise that debts are settled? Do we give someone a club and point them to the address and say, go and get it from them, or threaten their children to get them? No. We advise them to file legal proceedings in court. And so this entire thing was a bit strange, but in any case, the result is that the private data is not protected. The Data Privacy Commissioner has objected to this, and that made no difference. And so currently, if you want to go to a director's home and threaten them about something, look them up in the company's registry, and you have their residential address. The Register of Charges is not something, as I said, we are dealing with because I'm leaving charges to your commercial law course. And essentially, a charge allows a contract, that is a debt, a loan contract, to be given proprietary effect. And the distinction between contract and property is that contract only is binding against the parties to the contract, where property is binding against the whole world. So registering a charge in the company's registry essentially gives the entire world notice that a particular piece of collateral belongs, for the purposes of a loan, to a given bank, a given chargee. So the Register of Charges in the company's registry is extremely important for the existence of charges and their effect as protection of collateral. But we also have a secondary Register of Charges maintained by the company itself. And this allows you also, if you're lending money to a company, to another source of information to understand whether the company is in proper shape. That was disclosure made by companies, relatively brief. We will look in particular at the director's report in our application of law problem. Do also think about how these three types of disclosure relate to each other. In particular, the Veyron case is useful for that. And also think about why disclosure is useful and what kind of disclosure is useful. Perhaps you have an opinion on whether the addresses of directors, where their children and families live, is a good thing to make available to the world, or whether it should be considered to be private data.